may have lost the battle here today, but we're not going to lose this war, okay?
I'll admit I'm not exactly sure what Steve Bannon is talking about there after a jury found him guilty last week on 2 misdemeanor counts of contempt of Congress for refusing to comply with the January 6th committee subpoena last fall. He's now facing the real possibility of time behind bars. Now, not a lot of time. I would not be surprised if this all moves forward, that he ends up getting about maybe 30 days on each of the 2 counts, maybe a total of 60 days. The former Trump White House advisor has been making the rounds, blaming everyone for the verdict. The global elites, political persecution, January 6th committee's corrupt. But here's the thing. You can despise the January 6th commission. You can think it's highly politicized. And it still doesn't really change the legal case against him. This was a straightforward case. Bannon, through his lawyer, didn't respond to the subpoena beyond saying that he didn't have to respond. And by ignoring the follow-up and requests for testimony and documents, it's not a hard case. Bannon's initial claim that somehow his conversations with President Trump were protected by executive privilege were always nonsense, since he wasn't even part of the administration at the time and hadn't been for years. And a former president may not even be able to invoke it anyway. Most importantly, though, according to former President Trump's own lawyer, Justin Clark, Bannon had to respond and engage with the committee. In an email from 2 days after Bannon failed to appear for his deposition, Clark said, quote, "Just to reiterate our letter, didn't indicate that we believe there is immunity from testimony for your client. As I indicated to you the other day, we don't believe there is." Clark expanded on that during an FBI interview last month, saying, quote, that the former president never invoked executive privilege over any particular information or materials. The former president's counsel never asked or was asked to attend the defendant's deposition before the select committee, that the defendant's attorney misrepresented to the committee what the former president's counsel had told the defendant's attorney. Now, the judge, Carl Nichols, ruled against Bannon on a number of fronts. Nichols is a Trump appointee and a former clerk for Supreme Court Justice Clarence Thomas. There's a reason why other close Trump advisors, like former Chief of Staff Mark Meadows and social media director Dan Scavino, who also refused to fully cooperate with the committee, were not indicted. The January 6th committee wanted them indicted, but the Department of Justice refused because they didn't just blow off the subpoenas. They cooperated, at least to some degree. Meadows turned over 9,000 of his text messages and other documentations. They both were working in the administration on January 6th, making claims of executive privilege at least more plausible. And more importantly, their efforts to negotiate with the committee would have made it harder to claim their actions were intentional and deliberate. But I think Bannon is just loving all this attention. Even a conviction, possible jail time. Here he is on Tucker Carlson's show hours after the verdict came down, holding up his conviction as proof that there is a vast conspiracy.
Is a guy who tried to murder a gubernatorial candidate in New York was released with no bail. What are we to make of these 2 events occurring the same day?
Well, as you can tell, the Democrats are completely lawless, and look how they've run this committee. There's no ranking member. There's no minority counsel. It's not like the traditional hearings that have galvanized the nation in the past. And Tucker, I think it's one of the reasons that it hasn't really had that big an impact. You know, when they interviewed the people on the trial, I think almost all the working class people didn't even know what was going on.
Now, I think it's true that most working people know very little about the January 6th proceedings. But these jurors clearly understood what it means to blow off a subpoena. But here to tell me what I'm getting wrong is David Schoen, the attorney for Steve Bannon. He was also on former President Trump's legal team during his second impeachment trial. Thank you very much for coming on the show. Appreciate it. All right. So just lay it out for me. What am I getting wrong here?
Lots of stuff. With all due respect, listen, you are part of a family of legal royalty, so I take it as an honor if you're going to beat me up. But between you, your sister, your father, your brother-in-law, you've got it all covered, top level of the practice. So, but with all due respect, you got a lot of it wrong. I don't think it's your fault.
Tell me.
But you have a lot of it wrong. Let's start with Justin Clark. I hate to start there because it's a very minor part of the case. You wouldn't give a nickel for Justin Clark, believe me, if you knew him. I had to deal with him during the impeachment trial. But he's a thug, and he cooperates with the government now, so he'll say whatever they like. Let me read to you Justin Clark's letter to Mr. Bannon's lawyer, Mr. Costello. First, he goes into, what a horrible administration, the Biden administration, all of this nonsense. And then he says, President Trump vigorously objects to the overbreadth and scope of these requests, talking about the subpoena to Bannon, and believes they are a threat to the institution of the presidency and the independence of the executive branch. Through the subpoena, the Select Committee seeks records and testimony purportedly related to the events of January 6th, etc., potentially protected from disclosure by the executive and other privileges, including, among others, the presidential communications, deliberative process, and attorney-client privileges. President Trump is prepared to defend these fundamental privileges in court, and then he directs Bannon, through the lawyer, to the fullest extent permitted by the law, not produce any documents concerning privileged material, not provide any testimony.
But wait. That's a nice summary, but you claim that somehow I got something wrong. That is an overview. The question, though, was, what was the privileged material? What was it specifically?
What you got wrong, with all due respect, is mixing up the concepts of immunity.
I didn't mix that up. I was very clear in separating those two things. Immunity, I was very clear, means you don't have to respond at all. It's done. You don't have to show up, nothing. Yeah. Executive privilege is a different issue. On both issues, Bannon has a terrible argument. Terrible. And that's a legal matter. Then you throw in the fact that you can call him a thug. He is representing Donald Trump, is he not?
Was
representing Donald Trump at the time. And he has said that Bannon's lawyer misrepresented his exchanges to the court. I mean,
and Bannon's lawyer said otherwise in a declaration in the court.
I got it. Okay, the judge didn't accept your arguments, right?
In any event, there's no question, you raised the question earlier, whether a former president can invoke privilege. Nixon versus GSA, Kavanaugh's opinion in Trump versus Thompson. A former president can invoke privilege. The question is whether President Biden can override that, supersede the privilege. But in any event, the only question here in this case, why it's not so straightforward, is that the jury wasn't permitted to hear anything about Mr. Bannon's reasons for not complying. Mr. Bannon's lawyer wrote a letter that said, work out the privilege with Trump, or let's go before a court in a civil enforcement proceeding. If a court says privilege isn't valid, breadth of the privilege isn't like this, I have to comply to some degree, Bannon will comply. Bannon wants to testify. Why shouldn't the jury hear that full story? The judge had a question about his ruling on why they couldn't hear the full story. The judge said his hands were bound by a 1961 case called Licavoli that says, the simple question, did you get a subpoena? Did you show up? Doesn't matter the reason. That can't possibly be the standard for willfully. You know, Mr. Abrams, what the judge said, right?
Yep.
Can I just read that?
I know what the judge said. The judge basically did say in court that he isn't sure that this is the law as far as he's concerned, that it may be wrong. I understand that you guys are going to challenge that, but the notion that you're claiming and you're going to people who don't understand the law, maybe as well as I do, telling people that you've got a bulletproof appeal. You've got a long shot. You've got a long shot appeal. Come on.
Bulletproof appeal.
Come
Bulletproof
on.
appeal.
Come on.
Absolutely. Dan, the judge is remarkable. Have you ever heard of a judge? I've been doing it 36 years. I've never had a judge say, with the standard that he applied, I have serious reservations about the Court of Appeals interpretation. Willfully is consistent with a modern understanding of the word. It's not consistent with a modern case law surrounding the use of that term. All we say is let the jury hear the case.
Yeah, I understand. I understand, but you have to follow the law. And the judge clearly, I've heard plenty of judges say that they question appellate court decisions, but they have to apply the law in the appellate court. That's not some shocking revelation, right? Look,
absolutely shocking revelation.
Come on.
Dan, this year we had the case Ruan 3 weeks ago, before 2019, Rahafe. They clearly say willfully requires some knowledge or belief that your action is criminal or wrong.
Right, all you need to do is listen to Bannon on his podcast, and you know it was willful and intentional. He's announcing it every...
Let the jury decide. You're not the jury, and I'm not the jury.
But the jury did decide. And it was clear. It's willful and intentional.
Bannon was prohibited from putting any information forward as to why he didn't comply. Yeah. You know, Dan, listen, a person gets a subpoena from Congress. Yeah. How do you respond? It's not an intuitive process. And you know very well that his lawyer said to him, Bannon, executive privilege has been invoked. You may not comply, period. And you know that the lawyer's given a declaration. I don't know what you know, but the lawyer gave a declaration saying, I am relying on the Office of Legal Counsel opinions. Yeah, the idea, by the way, that one doesn't have to respond at all to when privilege is invoked. Yeah. I agree with you. It's a bizarre principle, but the Department of Justice has said that is the principle.
You guys are taking, on the whole, fringe arguments, and you are amplifying them. And I get it. And these are your best shots, right? Your hope is that on appeal, that the judge will get overturned, et cetera. And the judge did express reservations about that existing law. I don't know that it would have made much of a difference, because if his lawyer told him to do this, Bannon, the idea that Steve Bannon didn't know what was going on and his poor lawyer was just advising him on what to do here is so absurd. Steve Bannon knows exactly. I give Steve Bannon way more credit than that.
You have no basis in the evidence for saying that whatsoever. It's not an intuitive process. Bannon has testified 4 times in Congress before. He told them he wants to testify. He said his hands were tied because that's what his lawyer directed him. But just let the jury decide it. I'm not trying to convince you. All we ask is let the jury decide it.
David Schoen gets the final word. David, thank you very much for coming on the show. I appreciate it.
Thank you.
Coming up, thank you for watching. Go to newsnationnow.com to find News Nation on your cable provider. And don't forget to click the red subscribe button below to get more of News Nation's fact-driven, unbiased coverage.